Good morning.
Good morning.
Timothy McVeigh, O.J. Simpson, Martha Stewart. What do those people have in common? They all went through very famous trials about 25 years ago. To the surprise of many people, only about 10% of all lawsuits that are filed, the millions of lawsuits that are filed, actually make it to trial. So you're like, what happens here? There are 4 steps in a litigation process. The first is the filing of the papers, where the person who brought the lawsuit files a petition, and then the respondent files an answer. And this can go back and forth with counter claims on and on for months. The second part, and this is where it stops mostly, is the discovery period. And this is where you uncover the evidence. This can take years. So you're interviewing witnesses, you're taking depositions, you're examining records, you're asking for medical reports, and usually it stops during that process because it takes so long and it's so expensive. And people realize they don't really have as strong a case as they thought they did, so they negotiate a settlement. The third step is the trial, and the last step is the post-trial. What we're going to do today is talk about the deposition, and this is part of the discovery. It is a very powerful weapon. What you do at a deposition is you and I will be it, the deposing attorney, ask questions of the opposite side, the party that brought the lawsuit, which is going to be John. And the only other person that has to be there, and it's usually done in the law office, is the court reporter. That person is incredibly important because, first of all, they put John under oath that he tells the truth, the whole truth, nothing but the truth. Incredibly important. If he doesn't tell the truth, that's called perjury. You'd be put in jail for that. And the second thing that the court reporter is important for is she or he records everything that's said. What you're doing by a deposition is you are making that evidence firm. You cannot change your story, so you better tell the story right. And even if it's 2 years that we go to trial, that deposition is going to help or haunt you. And if you start changing your mind, you're going down a river that you'll never recover from. So let's do this. We're going to do just very quickly, 2 to 3 minutes, a depo with John and show things that possibly John could have done better. So John, thank you for helping me. I'm Anita T. I represent Walmart. We're so happy to have you come today. And let me sit down if you don't mind. And why don't you give me your name so we'll make sure we're all on the same page
Wells
here.
Fargo is my name.
Mr. Wells Fargo,
Yes.
Thank you again for coming.
Sure.
And what I'm understanding is that we're going to talk about a lawsuit that you filed on January 6th in 2018 against Walmart. And it was a slip and fall. You fell, a negligence case, and you're asking us to pay your medical expenses. And you seem to have some long-term problems and some emotional problems, which is preventing you from returning to work. Would that be true that we're talking about this incident on January 6, 2018?
No, that's not true. Don't you remember, it wasn't that date. It was 2 years ago in January. Don't you remember? That's when we had a lot of snowfall. That's what caused me to slip at Walmart, was the excess snow that was out there.
Well,
2 years ago, not...
Well, Mr. Wells, it's very important that we get this straight, because the weather is very critical in this case. And I have here the petition that you and your attorney filed, and by the way, your attorney did not come today, is that correct?
I don't need an attorney. They just cost money.
Okay, well, we just want to get that straight. But in this petition that you filed, and it says Mr. Wells Fargo versus Walmart, It says that the date right here, sir, is January 6, 2018. So we need to make sure that you're all right with that. But let's move on. Why don't you tell me why you were at Walmart that day?
Oh, that's an easy one. I was there to buy some oranges with my grandson Willie, my 3-year-old grandson Willie, and Willie was named after Willie Mays. He's a great kid. That's why we were there. That was the first time we were at the store.
Let me stop you on that. So you had never been in that store before? And we're talking about the store at 151st and alternate 69.
That's right. I've never been to that store.
Never had been to that store?
Never been to that store.
Well, Mr. Fargo, I'm just a little bit confused on that. I do have here an Overland Park police report that is about you, and it's right here. It was filed in 2015, and it seemed that you were at that store, and you had a little disagreement with the security guard about that fan that was underneath the cart that you did not pay for, and you went back and you had several discussions, and the Overland Park Police was called, and this was filed. Now, the store never brought charges against you, but we do have this report. You don't recall that at all?
Yes, that little unimportant matter. I believe I was questioned about some shoplifting, and that was a mess. Yes, I was at the store. That was the time I said I was at that. Yes, I was at that store. I thought you were talking about the time that I was there buying oranges.
Well, so we have straight that this was at least your second time that you had been in that store.
Yes.
At least 2 times, all right. And the first time obviously wasn't a pleasant experience, nor was the second time when you had a slip and fall. And so it's a negligence case. You're asking Walmart to pay quite a bit of money in order to compensate for your injury. You fell on your right ankle. You broke it. You've had, I believe, 3 surgeries on it. You're now, unfortunately, walking with a limp. And this has done emotional damage to you that you cannot work anymore, and you're asking for compensation for that also. Am I tracking with you correctly?
That's right. Walmart owes me.
Well, that's what we want to discuss more here. All right, at this time, we're going to end this little slides. Just stay right there, John. Thank you. Okay. There's a few things we want to learn from what John just did. His first mistake is he walked in without a lawyer. You don't do that. Okay. What you see at depositions, you see attorneys at their worst. There is no judge there. So they'll start asking irrelevant questions and go sideways, like get into his marital status. Has nothing to do with this lawsuit, okay? The lawyer would shut that down immediately and say, irrelevant, cannot put that in the record. And what you're doing is trying to build a case against him, okay? So that's his first mistake. The second mistake is he didn't even know the date of when this accident happened. You don't come unprepared. This is so important. What you say, you cannot change. That's in the record. He didn't have any idea what it was. He thought it was 2 years ago. It was within the last year. If this man is so confused on that, what else is he confused about? Okay. The other thing is that he needs to zip his lips. I asked the question, why did he go there? To buy oranges, period. He gets into Willie Mays. What is my mind doing? Willie Mays is 3. Maybe Willie Mays was distracting him when he left. He wasn't paying attention. He falls. We got a whole another road to go down here. The last thing and the most important is tell the truth. Even if it hurts, you've got to tell the truth. And that ends our deposition speech. Thank you, John.